In the case of Vellore Citizens Welfare Forum versus Union of India, this is a 1996 judgment. Supreme Court declared that the precautionary principle, now this time we come to the precautionary principle, includes three major conditions. The state must anticipate, the state must prevent, and the state must attack the cause of environmental degradation. It is a preventive principle based on precaution. Justice Oak and myself, we had headed a bench, and in Vanshakti we have delivered a judgment. We had set aside the office memorandum of the Government of India saying that it is violative of the environmental policy. Now, Confederation of Real Estate Developers of India, a Bombay, Pune based developers group, filed a review petition in the Supreme Court, and it was the initial original judgment was by a bench of Justice Oak and myself, two judgments. I am not because one of my judgments is under consideration. I will not say so, otherwise it will look like a crybaby. But it was placed ironically before a three-judge bench, of which I was also a member. And naturally my judgment turned out to be the minority judgment. The majority recalled that judgment. The original judgment said that insofar as environmental jurisprudence is concerned, ex post facto approval is complete anathema. There cannot be any ex post. You commit an environmental offense, you commit environmental degradation, and after 10, 15, 20 years, knowing fully well that these are the environmental norms, and after 10, 20, 15 years, by ex post facto approval, this is regularized. So basing on two previous decisions, Allenbeck and one more, we said that this is not acceptable, this is something different. Of course, in the review judgment, this has been recalled. I gave a dissenting opinion. It's not necessary to go into the dissent. All I am saying is that in my dissenting judgment in the review Vanashakti judgment, I had said that the precautionary principle is the cornerstone of environmental jurisprudence. Polluter pays is only a principle of reparation. Precautionary principle cannot be given a short shrift by relying on the polluter pays principle. In other words, if at all there has to be a grading of the different environmental principles, the precautionary principle has to be right at the top. Only when there is a breach of the precautionary principle and you rely on the polluter pays principle. So therefore you can't rely on the polluter pays principle to ignore the principle of precaution. That's the fundamental thing. Anyway, the rest is history. Now the new judgment has also come. Then there is another principle developed by the Supreme Court. The principle of sustainable development, which is very much a part of today's lecture, today's topic. In Vellore Citizens Welfare Forum, this is the case that Chaudhary was referring to. Supreme Court pointed out that it is very important to maintain the balance between industrial development and environmental protection. Hence the need to promote the construct of sustainable development. In this case, it has been held that precautionary principle and polluter pays principle are essential features of sustainable development. Sustainable development has come to be accepted as a viable concept to eradicate poverty and to improve the quality of human life while living within the carrying capacity of the supporting ecosystem. Because a developing nation like India has got development needs, it has got poverty alleviation programs, it has to be attended to also. Sustainable development means development that meets the needs of the present without compromising the ability of the future generations to meet their own needs. As a balancing concept between ecology and development, it has been accepted as a part of the customary international law. Now we come to that famous case of MC Mehta versus Kamal Nath. This was building a motel in the middle of a river, famously known as the Span Motel case in Himachal Pradesh. Supreme Court in this case developed the concept of public trust doctrine and held that the Himachal Pradesh government had breached the public trust doctrine by leasing out ecologically sensitive land for profit-making ventures. While Span Motel had to bear the cost of compensation and to face penalties based on the polluter pays principle, it was the Himachal Pradesh government which was pulled up for breaching public trust. Public trust doctrine primarily rests on the principle there are certain resources like the pollution-free air, like the water of the river Brahmaputra, water of the river Ganga, the forest, trees, etc., which have great importance to the people as a whole, that it would be wholly unjustified to make these resources a subject of private ownership. You can't have multi-story buildings on the bank of the sea to obstruct the free flow of sea breeze into the hinterland. So you find all the major cities, you have got major roads in the sea, facing the sea. You have got big promenades, as in Mumbai. You'll find that. So on the bank of the river Brahmaputra, you can't have huge complexes blocking the breeze from the Brahmaputra for the citizens of the city. That is this principle. This doctrine enjoins upon the government to protect such resources for the enjoyment of the general public rather than permit their use for private ownership or for commercial purposes. In this famous case, Supreme Court also emphasized on the principle of the most important principle of intergenerational equity, holding that the present generation has a duty to protect the environment for future generations. Intergenerational equity is based on the principle that the present generation has a moral and legal obligation to manage natural resources sustainably so that future generations can enjoy the same quality of life and access to resources that we enjoy today. It is based on the idea that we are not the owners of the earth, but its custodians, that we have a duty to pass it on to our children and grandchildren in a condition which we had inherited from our forefathers. That is the principle. Friends, from these court judgments, and there are many more court judgments, it's not necessary to go into all the judgments, we can safely reach the conclusion that Supreme Court has played a major role in developing such a wide, expansive and inclusive environmental jurisprudence in India. If Indian environmental jurisprudence has a parent, it is the Supreme Court. Environmental jurisprudence is Supreme Court's baby. It has nurtured and nourished it from its infancy. But having said that, I ask myself, all the conscientious citizens can ask themselves, today, where we stand today, looking back, do these decisions, do these judgments look very distant? Is it fading away, these judgments? My very distinguished colleague in the Bombay High Court, Justice Gautam Patel, he writes, even as a judge he has written extensively on citizenship and also on environment, has done an analysis of the Supreme Court judgment dealing with environment and published it in an article titled Consistently Inconsistent. That's the title of his essay, Consistently Inconsistent, Environmental Law and the Supreme Court. This essay has been included in the recent book, Incomplete Justice, the Supreme Court at 75, Critical Reflections, and edited by Justice S. Muralidhar. Those who are not from the legal background, I may inform the audience that Justice Muralidhar is a very distinguished judge of this country. He was a judge of the Delhi High Court, a very distinguished judge of the Delhi High Court. Circumstances I will not mention again it will lead to controversy. He was transferred to Punjab and Haryana High Court. From there, he became the Chief Justice of Orissa High Court. His farewell in the Orissa High Court is something Orissa High Court has not seen till date. Recently, he is in the news because the United Nations has appointed a committee headed by him, Justice Muralidhar, to look into the violence committed by the state of Israel on the innocent people, elderly citizens, women and children, the sick, those people in the hospital, in Gaza. This report is there in the public domain. Those who are interested may look into it. In this report, just by the way, just a digression, he said the state of Israel targeted children and on those facilities pertaining to children. The idea behind it is these children, when they will grow up, they will again become protesters against the Israeli nation. So better to finish them off, and their infrastructure. This is the idea behind this. This you will get in the report of Justice Muralidhar.